This is Trial Transcripts Exposed by Crime in Court with Heather. Raw courtroom reads with my commentary. Let's dive in. Hi, everyone. Welcome back to Crime in Court with Heather. This is Trial Transcripts Exposed. We are reading through the Menendez Brothers' second trial. First trial ended in a mistrial for the both of them. And we are now on the defense's case. Erik is on the stand. So Erik Menendez, the defendant, is on the stand, and he is continuing on with his uh, direct examination. And we're getting about to the end here, but I think there's like a couple more times where we'll have direct, and then we're going to get into cross. So, with that, let us get started and we will pick up right where we left off. And full disclosure, I'm not feeling the greatest, so my energy level's kind of low. So I apologize in advance. All right. So before we actually get into testimony, we're going to have some arguments by the attorneys here. So this is the afternoon, I want to say, or maybe it's the mid morning. I'm not sure. Um, I think it's the afternoon. They went on a break, and now the jury is back. So, or no, I'm sorry, the jury is not there, and the court is going to have this argument outside the presence of the jury. The court says, "All right, are we ready for the jury?" Mr. Levin said, Mr. Levin for uh, Erik. Mr. Levin and Ms. Abramson are for Erik. Uh, Mr. Gessler and Ms. Towery are for Lyle, and then we have Naguera and Mr. Khan are the attorneys for the state. I forgot her name for a second. All right, sorry. So Mr. Levin says, Your Honor, I'd like to be heard with respect to the testimony of Erik Menendez, where he was prohibited to testify concerning him being sexually brutalized by his father following his refusal on the tennis court to follow hand signals. And the testimony would be that Mr. Menendez had instructed Erik Menendez on how to cheat at tennis, that there was a rather elaborate system that had been developed over the years where his father would, at certain times, tell Erik Menendez what to do on the tennis court, and what he was supposed to do would be to cheat his opponent back. That they had practiced this, that he had done it on numerous occasions, and on this particular occasion, he saw his father give him the hand signal to cheat, and he resisted. It was one of the few and only times that he resisted one of his father's commands. The reaction of his father in resisting that command was that his father had sexually brutalized him. Now, to go to Erik Menendez's state of mind to evaluate his father's reaction to the belief that these things were occurring is absolutely relevant, and it's important for the jury to hear what would be in Erik Menendez's mind, what his state of mind, and what his belief that his father would do to him, or would do when he not only resisted an order that he gave him, but when his father forces sex on him because he refuses to follow these hand signals and cheats at tennis. Ms. Abramson says, Could I? Mr. Levin continues, What makes his father angry? What makes his father violent? These are things the jury has a right to hear. Now, Ms. Abramson and Mr. Levin confer. And Mr. Levin comes back and says, Your Honor, and the direct connection to his state of mind on August the 20th, 1989, that's the night of the crimes, is in evaluating for the jury to evaluate Erik Menendez's state of mind, which was his knowledge, hey, if my father reacts so violently, such as to brutalize me, force me to engage in acts of sex, and his reaction to not following hand signals, how would he react to the knowledge or the belief that Lyle Menendez was going to expose the family to a sex scandal? And remember, he's like a bigwig at RCA Records. He's not just a nobody. He has connections, money, power. He has a lot to lose if this all comes out. So yeah, I really do think that Jose had potentially he had to have had a plan if Erik were to come out and divulge the family secret. What that was, I don't know. But he had connections and money, and if he really wanted to make somebody disappear, I'm sure he could have. So if he wanted to make his own kids disappear and make it look like somebody was after him or something, I'm sure he could have. So I don't think that it's, you know, out of the realm of possibility that Jose and Kitty could have possibly been planning to take their lives or do something to resolve the problem, in a Jose manner. Because Jose solves problems the Jose way, which isn't how normal, rational people resolve problems. So it is very possible that something could have happened to the brothers had they not done something to the parents first. Mr. Levin goes on, I think that that's critical in allowing the jury to make the determination in a self defense case concerning why Erik Menendez did what he did. The court says, what is it that you haven't brought out? Mr. Levin says, I haven't been precluded by the court from bringing out the details of what occurred before the act of violence by his father. The court has sustained objection after objection by Mr. Khan whenever the word hand signal was mentioned. All the jury heard was that Jose Menendez was near the tennis court and that Erik Menendez disobeyed him, and that's it. But they don't know what it was that he saw, what it was that his father had done, what it meant to Erik Menendez when he saw his father use the hand signal. And these are important in assessing not only the reliability and credibility of how angry Jose got, but they have no idea at this point to know what it was that Jose Menendez was so angry about, or the fact that he could get this angry and crazy over something so benign. The court says, well, of course, the sexual assaults were described by the defendant in detail, totally unrelated to any of this tennis episode that you're now referring to. Mr. Levin says the relevance is not the sexual episode. It is the reaction of Jose Menendez to Erik Menendez's refusal to follow the father's orders to cheat at tennis. The court says the cheating at tennis is totally irrelevant. The disobeying of the father's direction, I think that's before the jury. So he's not letting everything come in and he's not giving full context. And this is part of the problem of why the defense claims things didn't get fully disclosed at trial because they kept hitting roadblocks with the judge. Judge continues, if you want to clarify that there was some hand signal by the father that the defendant saw and didn't comply with, that's up to you. I don't see what it really proves, but if that's what you feel would expand upon the offer here. But as far as what the specific issue that was the subject of the hand signal, I don't see that as relevant. Mr. Levin says what makes Jose Menendez relevant to Erik Menendez's state of mind in assessing the degree of danger in explaining his fear on August the 20th. And this is a situation where an entire component, an entire thread, if you may, has been pulled from the fabric of Erik Menendez's state of mind. So they're not allowed to bring all of this in. The fact that you could do something so small and receive an extreme amount of violence from your father. So that definitely plays the state of mind. The court says, you've got to be kidding. After all this evidence that's being introduced, you're making that argument? What did he say again? Okay, Mr. Levin says, what makes Jose Menendez violent is relevant to Erik Menendez's state of mind in assessing the degree of danger and explaining his fear on August the 20th. And this is a situation where an entire component, an entire thread, if you may, has been pulled from the fabric of Erik Menendez's state of mind. This really upset the judge for some reason. Maybe there was some kind of litigation prior to the trial, pre-trial hearings about state of mind, or I don't know. I don't know. But whatever it is, the court says, you've got to be kidding me. After all of this evidence that's been introduced, you're making that argument? Mr. Levin says, absolutely, Your Honor. And first of all, the court has no say in what arguments a defense attorney puts forth for their client. A defense attorney is going to put forth whatever arguments they can to the best of their ability, and all of the arguments that they can that can best put their client in the best um, position. So the judge has no say in what the lawyers can and can't argue. He can deny something, but for him to be like, "Are you kidding me? You're arguing this?" This is odd, and this makes me think that they are trying to hide the ball from the jury here. Mr. Levin says, absolutely, Your Honor. The court says, well, the objection is sustained. Let's go on. All this evidence has been allowed. The court has allowed a very broad range of inquiry of this witness, introducing all sorts of evidence from childhood on up. And to make this argument at the stage about that one issue just boggles the mind. Remember, at this point, Lyle doesn't testify in this trial, so everything that's coming in about their parents is either coming in through other eyewitnesses or Erik, and it's all on Erik. And Erik can't necessarily be the recipient witness to all of the things that Lyle experienced, so we're missing a lot of things, and the jury is missing a lot of things here. So it's not, they're getting some of the picture, but definitely not the picture that we got in trial one, which you had so many experts leading up to Erik and Lyle's testimony and telling you this is why they did the things that they did because they were so frightened and they endured so many years of abuse up until that point, and that's led to their mindset. So all of it is relevant, and yet the judge is still like, no, I don't want to argue this. It's sustained. It's all relevant if it goes to their mindset, if it's a self-defense, you know? Anyways, what did he say? The court has allowed a very broad range of inquiry, introducing all sorts of evidence from childhood on up and to make this argument at this stage about the one issue just boggles the mind, says the court. Um, F off, Judge Weisberg, because it's not your job to decide what the attorneys argue. Mr. Levin says, Your Honor, there's no such thing that I am aware of the law where an attorney defending a defendant in a capital case should balance the weight or force of the evidence that's been adduced in relationship to what evidence what that remains should or should not come in. And I don't think that I'm aware of any law that stands for the proposition that when the court reaches a point of saturation with the degree of evidence that other relevant evidence should be withheld. The court says, okay, well, I've already indicated it's not relevant. So the judge has the final word, and that's that. You can just shut up, Mr. Levin. Mr. Levin says, well, this evidence, I believe, is, and when I argued, court says, okay, you've had your statement on the record, and I've given you my ruling. He just cuts him off. Wow. Ms. Abramson says, Your Honor, could I say something? I realize there's a one lawyer rule, but I don't like the nature of the exchange here. Just to calm it down, me, the calming figure for the moment. Mr. Levin says, We're fine. Ms. Abramson says, Okay, but I think the crucial point is the genesis of my client's belief under the flannel theory. Don't know what the flannel theory is. The court says, believe me, I know that. That's the only issue that has justified the introduction of all this evidence so far. So he's saying I've been lenient. It's the only reason that you're getting this evidence in. Ms. Abramson says, I understand that, but the court may recall that one of the things he feared just before the shooting was a sexual assault by his father, and that sexual assaults were used as punishment. And I think the jury should be able to assess the degree of violation, if you will, that results in punishment by the father. The fact that it was cheating at tennis or not cheating at tennis, even if it was to do something appropriate in tennis, I don't think is relevant either. But I think that at least my client should be able to explain specifically what the signal was and what he refused to do so they can weigh how angry his father got over refusing to do that small of a thing. Whether you call it cheating or not doesn't matter. Great point there by Ms. Abramson. Court says, well, I can assure you that the way it will come out that way from the inquiry. The issue is whether or not the father gave him directions that the defendant disobeyed and the reaction of the father and the defendant's reaction to the father's reaction. Okay, that's all before the jury. Now, if you wanted to expand on that, as I said before, to detail what the signal was, if that is significant to you, you can do that. But as far as the detail of what was going on in the game and what it was that the father specifically wanted to do, I don't see that as relevant. Mr. Levin says, I apologize, Your Honor. The court says cheating's not relevant. That's just character assassination of the father for no reason. Don't you think it's important to know what kind of people they were? Because it might explain why circumstances turned out the way they did. Don't you want to know who he was? I guess not. The court does not want the truth. You see it here. Mr. Levin says, I apologize, Your Honor, for misinterpreting what the court said. The court says, I don't see any reason to go into the specifics of the game or the nature of what the father wanted him to do. Mr. Levin says, so Mr. Menendez would testify to what the hand signal was and what it meant. Court says, not what it meant. No. What it meant, obviously, is the issue is what you're talking about, cheating, right? Mr. Levin says, yes. Ms. Abramson says, to do something. The court says, just a hand signal to do something. We've already got that out. Mr. Levin says the court interrupts him and says, I've already ruled on this already. We're going over the same thing again. Mr. Levin says, I don't think that I've made it entirely clear. The point is, too, it goes to the control and domination of Jose Menendez that here he is from like a remote control device from many feet away can control Erik, and I think that's important in assessing the degree of control that Mr. Menendez had. Ms. Abramson says, May, the court says, obviously, he didn't control in that situation. That's what his testimony was. Ms. Abramson and Mr. Levin confer. Mr. Levin says, I just need 1 second with my client. He confers with Erik Menendez. The court says, all right. Anything else before the jury comes out? No, Your Honor. I'm still attempting to get in this DMV record. The court says, I did ask for you to show me the document, and you had some case you wanted me to look at. I've never seen one yet. I've been here. Okay. Ms. Abramson says, what was that you? You were here? Court says, until we have time for me to look at it, I can't rule on it. So let's proceed with the jury. Ms. Abramson says, I asked Detective Zoller to pull the original. These are from the Beverly Hills Police Department documents, and the number of on the bottom. I have no problem giving you our research if that would assist the court. And he says, all right. Now the jury enters the room. The court says, okay, the jury is back and will continue with the direct examination of the defendant, Erik Menendez. Mr. Levin says, thank you. Mr. Menendez, directing your attention back for just a moment to that incident that occurred in Arizona where you received a hand signal from your father and you disobeyed it. Have you ever before disobeyed such a hand signal given to you by your father? Only once. When did that occur? When I was 12. What occurred when you disobeyed your father's hand signal? First of all, was it the same hand signal that he gave you in the Arizona tournament? Yes. And what happened when you were 12 and you disobeyed it at the time? I learned not to do it again. My father held me up against the locker room door and told me never to disobey a direct order of his. Was that the incident that you described where Lyle Menendez? There was another time when Lyle did the same thing. I was a year or two younger at that time. When your father had indicated to you that you were disinherited, did you believe him? Yes. Did it affect your life in any way? No. Why not? Whether I was in his will or not in his will didn't matter. I was still living at home and everything was still being paid for, and my father was only 45 years old. It didn't make much difference. Exactly. Exactly. That's perfect answer. My dad was young, in his decent health, I guess. I mean, I think he smoked, but other than that. And yeah, why would he why would he think anything differently? Why would his world didn't change because he was in or out of the will? Do you remember? I want to ask you a couple more questions about the safe incident at Randy Wright's house. Do you remember going to Randy Wright's house and seeing the safe in the garage? I remember going to Randy Wright's house. I remember seeing the safe in the garage. Do you remember the circumstances under which it was open? Yes. And how? First of all, how did you get to Randy Wright's house? I came over in a limousine with my Uncle Brian and my Uncle Carlos, I believe Lyle, and I had thought the locksmith, but I could be wrong. Do you remember who it was that arranged for the attendance of the locksmith? I believe it was my Uncle Brian. So they had this safe, but the family's trying to open it, not necessarily the brothers. Remember, they bring it from their home to Randy Wright's house, who they were staying with for a couple nights, and then they had it opened in the garage with a locksmith, and then there was nothing in it. And when you got to Randy Wright's house, was there ever any discussion in the garage concerning the circumstances that the safe would be opened? Yes. What was the discussion? Well, the locksmith didn't want anyone in the garage when he was opening up the safe. We stepped outside. When the locksmith said that the safe was now open and could be opened, my brother asked my uncle Carlos if he could open it privately, and he told him that there could be many embarrassing family secrets in there that he does not want exposed, and they agreed. This is a signal to me that maybe the brothers knew that there might have been some thing that rhymes with corn. Maybe um, the pictures of them when they were younger. Maybe they knew that those existed. I don't know. But they knew that their father had some proclivities that he didn't want exposed to the general public. So they wanted to open the safe in private just in case something embarrassing might be in there. Why did you believe the locksmith didn't want you in the garage when he opened the safe? I don't know. He just asked all four of us to step outside while he was drilling to open the safe. Maybe it was something could explode. I don't know. Oh, that's such a naive, sweet little answer. He's like, I don't know, something could explode. He just didn't want us in there. And was this how big was this garage? I don't remember if it was a 3-car garage or a 2-car garage. It was 20 or 30 feet by 15 feet. Do you remember looking inside the safe? Yes. What did you see inside the safe? A key. I specifically remember a key. There might have been some papers explaining what to do with the key. Did you remove those items? Yes, yes. Did you learn that there was a safety deposit box that was related to the key? Well, my Uncle Carlos was across the garage and he came over and he said that it must be for the safety deposit box. Did you in any way try to conceal the existence of the key and the papers from that safe? No. Did you inform your Uncle Brian as to the existence of the key? They were in the garage at the time. We just said there's nothing much in here. Was a key something that you were looking for that you felt could be embarrassing to the family? No. Was there any computers in your house? There was a computer, yes. And where was the computer? It was an IBM computer in my parents' bedroom. Had you ever used that computer? When I was very young, 12, 13, I used it. Did you know how to use the IBM computer in your parents' room? No, I was banned from using it when I was 13. Why? I had, by accident, was fiddling with it and erased the hard drive. Uh-oh. How big is the computer? Would you show us in your hands? It was an old computer, about 15 years now, just the monitor, and there's a big base that the monitor sits on. There was a printer on the side of it. Could you pick up the computer if you wanted to? Yes. Was the computer attached in any way that would preclude you from removing it? No. Was it plugged in? It was plugged into the socket in the wall. Did you ever attempt to destroy or conceal the computer? No. Eventually, did you use that key that you found out inside the safe? Yes. And where did you use the key? My uncle Carlos, Brian, Lyle, and I went over to, I don't remember the name of the bank, in Beverly Hills that the instructions said to go to where the safety deposit box would be. Did Uncle Brian and the other members of the family that were there at the time know that they, did they know that the key went to that safety deposit box? I assume that's why we were there. Were they along with you when you went to the bank? Yes. What happened when do you remember what happened when you went into the bank? Yes. What happened? The bank manager didn't want to let us into the safety deposit box. There was some discussion or argument over whether we would be allowed access. My uncle Carlos was I don't know if he was the executor at that point, but he was taking charge and saying that my parents were dead and needed to get inside looking for a will, and eventually the bank manager let us in. Who was present when the safety deposit box was opened? You mean actually in the small room? Yeah. The bank manager opened it and took out its contents first. And did you examine the contents? Yes. What was in there? Some jewelry, some papers. I no longer remember the specifics of what was in there. There was jewelry? Yes. Did you take the jewelry? No. Did Lionel Menendez take the jewelry? No. What did you do with the jewelry? My uncle Carlos and my uncle Brian were waiting outside the room, and we called them in and showed them the contents, and I assume they took possession. When you discovered the presence of or the contents of the safety deposit box, who was present at that time, the first moment that you knew what was inside there? I believe it was simply my brother and I, and the bank manager was standing next to us, but not next to us, but behind us. And the bank manager gave you then access to the contents of the safety deposit box? Yes. Did you bring any bags with you? Empty bags? No. Did you look through the papers? Yes. What were you looking for? Photographs. Any type of evidence that my mother might have put inside the security box about what was happening between my father and I. That's what I was looking for in particular. They had asked Carlos and Brian if we could look, I think he said, I think it means I, or we had asked Brian and Uncle Carlos and Brian if we could look in there first in case there were any secrets, and I was specifically focused on that. What happened? Did anything else significant happen at the bank? Not that I remember. How long after the death of your parents were you at the bank did this incident occur? I think it was on Wednesday, perhaps a Thursday. Within the first week? Yes. How would you describe your emotional demeanor at this time? Very somber, sad, quiet. How are you feeling about the death of your parents? A lot of regret, guilty, just sad. Were the family members starting to arrive in California from out of the state by this time? Tuesday, Wednesday, even Thursday they arrived. And was there a service that had been planned in any particular place? Yes. Where? At one of the guilds, actor guilds or director guilds in Hollywood. Did you attend that service? Yes. Do you know who Marcy Eisenberg is? Yes. Who is she? She was my father's personal secretary. How long had she been your father's personal secretary? For a very long time, 10 years. Did your father and Marcy Eisenberg seem to have a close relationship? I don't know if my father had a close relationship with anybody. I don't know what you mean by close. Marcy knew a lot of things my mother didn't, so he was close. Objection calls for hearsay and speculation. Sustained. The answer is stricken. How did you get to the funeral? Limousines. Several limousines were taking the relatives. Was the funeral, and this is a funeral service at the Directors Guild, is that correct? Exactly. From where did you take the limousine? I believe it was from the Beverly Hills house. Who was in the limousine that you rode in on the way there? Yes. I believe my grandmother was there, my brother, myself. I don't remember who else was there on the way to the service. Do you remember ever being in a limousine with Marcy Eisenberg? Yes. Where did that occur? On the way back from the service. Do you have a recollection of Marcy Eisenberg being in the limousine on the way back? Yes. Who else was in the limo on the way back? Myself, my brother, I believe Carlos Menendez, but I'm not sure. You heard Marcy Eisenberg, you heard her testimony? Yes. You heard her testify that there was a conversation in the limousine? Objection calls for hearsay and irrelevant, says Mr. Khan. The court says, are you going into that area that we had talked about? Mr. Levin says, no, Your Honor, that will come in later. I just want to establish that he was present. The court says, didn't you ask for the content of the conversation? Mr. Levin says, I wasn't going to. The court says, all right, then let's ask the question again then. Mr. Levin says, were you present in the limousine during the entire ride back? Yes. I want to ask you some questions now concerning any knowledge that you had concerning your father's wealth. Did you at some time learn that you had not been disinherited? Yes. And how is it that you learned that? Over time, the relatives were searching for, they had had the old will. They were searching for the new will, and until that was found, eventually they stopped looking and no attorneys, they called a lot of attorneys. So eventually it was just established that no new will had been created. Eventually, there was a will that was found? Yes. Was it your understanding that you were or were not in the will? The new will had my brother and I as recipients. Who told you that information? My Uncle Carlos. And did you know what you would inherit? What my father had. I didn't know specifically. Did you know specifically what your father had? No. Had your father ever made you aware of the extent of his financial dealings? No. Had your father ever made you aware of the extent of his wealth? No. Was there any discussion about insurance? I remember my father discussing it with my mother at the dinner table several times. What was the discussion about? That my father, the company, was going to give my father a $5 million life insurance policy and that the only thing left to do was simply to take the physical, and my mom wanted him to take the physical, and he had been asking him to take the physical for many months, and he kept putting it off. And finally, he said that he had made an appointment for September of 1989 to take the physical. So he died on August 20th, so he never made it to that appointment. At the time of his death, did you have knowledge as to whether or not he had taken the physical? Well, he had not taken the physical. And do you know why he hadn't taken the physical? I know that he had had a heart attack in January or heart tremors, and that my mom also wanted him to take the physical, and so I wasn't specifically told. I just assumed. Calls for hearsay, motion to strike. The court says objection sustained, the answer stricken. Mr. Levin asks, the previous answer as oh, Mr. Levin asked the previous answer as well. Was there, Mr. Menendez, did you receive any information that following the death of your parents that you were going to get some money, some insurance money? Yes. And was this life insurance? Right. Did you understand how much that you were going to receive? My Aunt Marta was giving a lot of different figures about what the estate was worth and the insurance policy that she had taken out. At that point, she was trying to give a lot of figures. I don't specifically remember. Who is Aunt Marta? She is my father's sister, my aunt. And to your knowledge, does Aunt Marta have any special experience and training when it comes to money? Yes. What is that? She's an investment manager, a stockbroker, personal package type of investment type of thing. What relationship did you have with Aunt Marta? She was one of my favorite aunts. Were you close to her? As close as I could be. Did Aunt Marta have anything to do with the money that you received from your father's death? Yes. And what was that? She she had arranged for us to get the insurance. So she took out the insurance policy. So once you obtained the insurance proceeds, what did you do with the money? I gave it to my Aunt Marta to take possession and basically to manage. I didn't know anything about money really, and so she was willing to give me advice. Following the death of your parents, did you have a future planned for yourself? I had no plans. Did you want to do anything particular in your life? I wanted to do what my father wanted me to do, which was play tennis and go to college. Did Aunt Marta assist you with respect to seeking assistance into any particular school? I felt that my father would want me at Princeton with my brother, and so she helped try to arrange me to get in the school at Princeton and arrange the meeting with the dean that I had in September. Did you see the dean at Princeton? I met with him, asked him if I could start school, even though I believe it was a little late, and asked him if I could begin that semester. And I explained to him what had happened with my parents and that I believe this is what my father would want me to do. And he said that it was too late, that I was going to have to reapply for the next semester. Did you want to go to Princeton? No. Did you think that you could succeed in college? I wasn't sure that I could. Why not? Without my mom and dad helping me through the work, I wasn't sure that I could pass. Now, how was it that you communicated to Aunt Marta that you wanted her help to that you wanted her to help you with the money that you received from the parents' death? I had some conversations with her and that I didn't know what to do with the money that I was going to be getting. I didn't know anything about the banks, about how banks work, or never had a checking account. I had never kept taxes. I had never invested anything. I didn't know anything about money, and she advised that I just give it to her and that she would give me her credit card and a checking account, and I would send everything to her, and she would take care of it for me. It's really nice of her. And is that what occurred where she took control of the money and gave you a credit card? Yes. Did you also get a checkbook? Yes. Did Aunt Marta give you any advice with respect to investing money? She asked me if I wanted her to invest on her own. I said whatever she feels is best. Several people were telling me to invest in real estate, but I'm not sure if my Aunt Marta was one of them. So she might have had other like stocks and bonds and things that she might have wanted him to invest in aside from real estate. I think she was a stockbroker, so she was telling me to invest in stocks. Did you want this money, Mr. Menendez? I wasn't sure that I wanted the money. Who else in your family was giving you advice with respect to investing any money? My Uncle Brian. Does Uncle Brian have any special knowledge with respect to business investments? He's a wealthy real estate businessman, invests in real estate. Anyone else? Strike that. What did Uncle Brian tell you about what you should do with the money? He told me to invest it in real estate. He told me that if I gave him $3 million that he could do a lot with that and just to basically give the money to him, allow him to invest it and he would take care of it and my investments in the future. Not for nothing. I'm just saying, Uncle Brian, we know later basically disowned the brothers and was like trying to sue them for wrongfully taking his sister's life or I don't know what the charge was, but he was trying to sue them for money and all this. And then he later, turned on the brothers and they think that it was out of, cold hearted, cold or murder and cold blood, not out of fear. And they didn't really buy the whole abuse thing, which I don't know how you can't, having watched the trial. So if Uncle Brian watched any of their testimony, I don't know how you can go with the state's theory, but that's what they did. If you recall, recently, Uncle Brian passed away. I want to say last year, like at the beginning of last year, and he was the last opposing member of the brothers getting paroled. So it was actually kind of fitting then that they got approved for parole shortly thereafter. All right, so where were we? He told me to invest in real estate. Did you have $3 million? No, he was just speculating on what I might get when the estate unfolded. And so he was saying give the money to him, he'll invest it, and maybe after college I'll work with him. That's what he wanted me to do. What it was My whole point about the money before I started reading again was that, do we trust Uncle Brian? Because Uncle Brian turned on them. Was Uncle Brian going to be honest with them with their money? Or was he trying? I definitely think Aunt Marta was going to be honest. Aunt Marta and Joan are the real ones. But Uncle Brian, we don't trust him now. So was he just trying to get a hold of that money? Did he think that that money was going to be his to manage? I don't know. It's interesting. How much did you actually receive following the death of your parents? 250 to $300,000. This is just the payout, the initial payout from Aunt Marta's insurance policy. And did you give that amount of money to Aunt Marta? Right. You heard testimony in this trial concerning you purchasing a Jeep. Did you buy a Jeep? Yes. When following your parents' death, did you buy a Jeep? Late October, 2 months later. Was this a particularly happy event in your life to acquire a Jeep? It was a very depressing time in my life. I was giving my car to my Aunt Marta. I bought a Jeep. Did you in any way keep secret or conceal the purchase of the Jeep from the family? No, the family was giving me advice on the Jeep. So they were the ones telling him, buy this one, not that one. They're the ones spending the money. They're the ones over his shoulder going, look, this is what you should buy. This is what you should do with the money. And here the state is like, oh, the brothers were just spending it all everywhere. He says, no, the family was giving me advice on the Jeep. Were you alone in your decision to ultimately purchase this Jeep? Had there been any discussion about it before? Yes. Who did you discuss it with? My Aunt Marta, my brother Steve Goldberg, who was, I believe, the attorney for the will, perhaps. He was one of the attorneys in this. Who was, or maybe it was the attorney for the, uh, yeah, for executing the will, I think. Don't quote me on that. But anyway, so he says Marta, my brother, Steve Goldberg, who had become a friend, was the lawyer for the estate for my uncle Carlos and my aunt Terry, my cousin Henry. And as a result of the conversations that you had with cousin Harry and Aunt Marta and attorney Goldberg, did anyone disagree with you buying a Jeep? No. Did any of those people assist you in the buying of a Jeep? My Aunt Marta assisted me in, I guess, arranging for the financial arrangements of it, and Steve Goldberg went with me to actually buy it in terms of negotiate with the. Had you ever in your life negotiated the purchase of a vehicle? No. Who negotiated the sale and the purchase of the Jeep? Steve was going back and forth with numbers with the man there. You heard testimony in this trial concerning the purchase of a wristwatch, a Rolex. Did you ultimately obtain a Rolex wristwatch? Yes. And when did you obtain this wristwatch? when I was in Century City buying a sports jacket to wear to the funeral. Had there been any plan for you or arrangements made for you to visit a jewelry store when you were at Century City before you went there? No. Had there been any discussion or decision made for you to obtain a Rolex wristwatch before you went to Century City? No. What was your purpose for going there? I didn't have any suits or sports or blazers to wear that really fit me anymore. I think I had one or two from long before, so I needed one. So I was never going over to Bullock's to get one. I don't know what that means. Who did you go to Bullock's with? My brother. Bullock's must be the store. When you got to Bullock's, did you buy any clothing for the funeral? I bought the jacket and I bought a pair of loafers. After you bought the jacket, did you leave Century City? Strike that. Did you have to wait for anything after you bought that jacket? It was being fitted. It was too big for me, either in the sleeves or the waist, and it needed to be fitted. So I think I had to wait an hour or two, maybe. During that hour or two, did you go to the jewelry store? It was one of the places we went. Where else did you go? It's an outside mall, and my brother and I were talking and walking along the stores, stopping at windows and just talking, going in and out of stores. When you ultimately went into the jewelry store, did you know as you walked in that you were going to buy anything? No. So it was an impulse purchase. Everything else they planned to get the coat, they planned to get the Jeep, planned to look at real estate, all those things were told to him by family members' advice. And did you buy anything inside that jewelry store? Yes. Did you pick it out yourself? My brother was looking at different things. He looked at a watch. I said, "Why don't you buy it?" And we eventually did. How would you describe your demeanor during this purchase? Were you happy and excited to get a Rolex wristwatch? No. It was a very gloomy period for Lyle and I and the rest of the family. We were happy to be together in terms of the family, but the atmosphere was not happy. Who paid for the wristwatches? My brother did. And there was more than one wristwatch purchased. There were, I think, three. Of the three wristwatches purchased, how many did you get? One. Did you get anything else? Other things were bought, clips for money. I don't know what else. Remember, Lyle bought a money clip. Was there a telephone call made from within the jewelry store? Yes. Who made the call? My brother. And did you hear that conversation? I was in the store. Do you know who your brother was talking to? I believe he was talking to my uncle Beralt. Objection calls for hearsay. The court says objection sustained only for the purpose of establishing a foundation. Perhaps you can do that. The answer is stricken. Mr. Levin says, did you have any discussion or intention of keeping the purchase of the wristwatch a secret from any of your family members? No. To your knowledge, was it made known before the purchase of those wristwatches that people in your family knew? At the store, I remember the conversation that my brother had with my uncle Carlos about asking how he should pay for them, if he should use a credit card or what he should do. Basically, asking advice about what to get. Maybe not what to get, but how to pay for it, or just telling him that he was getting it, and I just remember that part of it. And that was before the purchase was made? Right. Did you see how the purchase was made by Lyle Menendez? Did you see how it was paid for? A credit card. Whose credit card? My father's. Did you recognize that credit card? It was one that my father had given to my brother a year or two, 3 or 4. So to your knowledge, your brother had that card long before the death of your parents. Yes. What kind of card was it? It was a gold American, I believe it was an American Express card. To your knowledge, did your brother have permission to use that card? Objection calls for speculation and hearsay. Overruled. The witness says yes. Was this the same card that was ultimately used to pay for the camcorder? No. The card that the camcorder was paid for was on my brother's credit card. To your knowledge, your brother had your father's American Express card as well as a card for himself? Right. Was there a time when you left California and went back east for an additional memorial service? Yes. When did that occur? I left California the day after the memorial service in California, and the funeral took place perhaps the Monday afterwards, Tuesday afterwards. Where was your father and your mother buried? They were buried in Princeton, New Jersey, in a small cemetery inside Princeton. Have you ever visited the grave? Yes, I used to go there with my brother. When the service was conducted in New Jersey, did you have a discussion with any person in your family where the subject of a computer came up? Yes. And who was it that you had this discussion? With my Uncle Carlos, Carlos Menendez. You have two Uncle Carloses, correct? One is my father's first cousin, Carlos Menendez, and the other is my father's brother-in-law, Uncle Carlos Baralt. And which Carlos was it that you had the discussion with concerning the computer? Carlos Menendez. Who first brought up the subject of the computer? He came to me and said that there was a computer. What did Carlos Menendez tell you about a computer? Objection calls for hearsay. The court says, is this being offered for the truth or to reflect the witness's state of mind? The latter, Your Honor, says Mr. Levin. Court says, it will be received for the purpose only. Thank you, says Mr. Levin. Erik says, he told me that there was a computer in my parents' bedroom and that had some files on it, and he was interested in that he wanted to get into. And I said, well, it's an IBM computer. Why don't you ask Eileen, who worked at IBM? And Eileen was brought into the conversation. I brought her over and told Eileen, I said, apparently there's a computer that has these specific files on it, and my Uncle Carlos had tried to get into it, I guess, at the house, and in general, there was a lot of discussion amongst the family members that day about this computer. Mr. Levin says, now Carlos Menendez had been in California for the memorial service? Right. Did you interpret this discussion about the computer to reflect something that he had done in California with the computer? He and others. He and others. What was it that you understood that he and others had done to the computer that was inside your house? From the discussions at the memorial service, my Aunt Joan, I believe another relative, were trying to get into the computer to look up any type of files, and there was a lot of discussion about the possibility that there could be a will on the computer. And I remember my Uncle Carlos Baralt, who I guess was the executor at that time, said that a will on the computer doesn't interest him because whatever reason, it's on the computer and therefore it's not valid. It needs a signature, something along those lines. Who's cousin Eileen? She's Marta's, I believe it's her eldest daughter, who at the time worked for IBM and was very good. I wanted her to go back and look at it herself, but instead of flying all the way back, she said she could have someone from IBM in California come out and look at the computer. Where was Lyle Menendez when this conversation took place? My brother wasn't in this conversation when it was discussed amongst the relatives. My brother was at the memorial service. Who was back at the Beverly Hills home? I don't believe that anyone was at the Beverly Hills home. I know that there were security guards that were guarding the property. Upon hearing that there was something when was the first time that you learned that someone had seen something in the computer that had to do with a will? At this time? Before that, did you see the family when you were in California fiddling with the will or fiddling with the computer? No. The doors were open. My grandmother was assuming control of the house, but relatives were, I believe, they were even staying at the house. Most of them were staying at the Bel Air, the Bellage Hotel, but they were over the house throughout the day. I wasn't. I wasn't there often. When I was there, they were there. I didn't see them at the computer. Now, had a decision of some sorts been made with respect to checking the computer further for the existence of a possible will? Now, had a decision of some sort been made with respect to checking the computer further for the existence of a possible will? A tentative decision that my cousin Eileen, was going to try to get someone in California to be able to go over to the house. Someone needed to be at the house. It was decided that I would fly back and meet the computer people at the house. Did you, in fact, fly back and meet the computer person at the house? Not these computer people that had been arranged at that time, but a different computer person. Was there an actual arrangement made by a family member to look at the computer in the Menendez house? Yes. Who made those arrangements? At first, it was my cousin Eileen. She told me that she had set it up. And then several days before I was supposed to leave, my uncle Carlos Menendez, told me that he had spoken with Eileen and that they were going to use Carlos Menendez's people instead of Eileen's people. Fortunately, I didn't check with Eileen to make certain of that. I just assumed that that was true. How long were you in New Jersey, would you say? 5 days, 6 days? The court says, let's take a recess now and we'll resume at 10 minutes to the hour and work on until 1 o'clock. We're not going to break though. We're going to keep going. Um, the jury exits the courtroom and the following proceedings are held. So we're going to have some arguments over this computer. The court says, on a couple matters, I received a fax from Mr. Heinke? Hanky? I don't know how you say that. To me, it looks like Hanky, like Mr. Hanky, the Christmas, you know what, from uh that's what it reminds me of. But I guess I don't know how you would say that. Heinke? Hanky? We're gonna go with Hanky. All right. So the court says he received a fax from Mr. Hanky from South Park. Sorry, this just childhood memories of Mr. Hanky, the Christmas poo. Sorry. So Mr. Hanky, relating to the protective order. I don't know if the prosecution has received it and had a chance to review it. Have you read it yet, Mr. Khan? Mr. Khan says, no, Your Honor, I haven't had a chance to read it yet. The court says, if you could do that, we can resolve it hopefully today. The other issue relating to the DMV printout, as I understand it, the incident that you're referring to was September the 7th, 1989. Ms. Abramson says July 7th. The court says, I'm sorry, July the 7th, 1989. It indicates that court proceedings were on September the 20th, 1989, so that couldn't be the one that you were appearing on. Ms. Abramson says, no, it couldn't be the one I was appearing on, but I think it was the one that my client was testifying about that he got a ticket that day. The court says, I think that the 12951A has a provision for these matters to be dismissed and the driver's license is produced in court or shown to the marshal. I don't know if anyone's checked the dockets or if these files are still in existence. I doubt if they are. But this record doesn't really prove anything. It proves he didn't have it in his possession at a particular moment when he was stopped by the police. It doesn't show whether or not he lost it, just that he was stopped by the police and didn't have it. Ms. Abramson says, doesn't have to be the ultimate proof of the fact. He's saying that he lost it, and I think he's saying he lost it, and he's saying he got tickets for not having it. Now, if the people want to prove that, that what you're saying, that he produced it in court, fine. If they want to impeach them, if they want to impeach them with that, I don't think they can because I don't think he had one. But I think he had a right to show that he was driving around without a license in July if he says that's because he didn't have one. They can impeach him if he's not telling the truth. The court says, well, all it proves is that he was given a citation on July the 7th of 89 for driving without a license, same in July of 88, June of 88. Ms. Abramson says he had a penchant for losing his license. The court says it just shows that that's what was going on. It doesn't show whether he didn't possess a license or didn't own a license or just that he didn't possess it at the time or didn't produce it at the time. That's all it's showing. But it's still evidence, Your Honor. And it helps to prove the defense's point, but he doesn't want that out there because He doesn't want the defense to gain any leverage. Ms. Abramson says the prosecution can argue it. It doesn't mean that we can't use it to corroborate what he's saying is true, that he didn't have it. The fact that it doesn't prove the ultimate fact, we're not suggesting that it does. They can argue whether they want to argue or prove whatever they want to prove about it, but it corroborates him to the extent that he's saying he didn't have one. The court says, all right, he didn't possess one on a particular day. Ms. Abramson says, that's right. The court says, that's all it corroborates. Ms. Abramson says, well, fine, but he's saying he didn't possess one on any particular day after he lost it, and that just corroborates that on one day he didn't. I recognize that it can prove, I recognize what it can prove and what it can't prove. The court says, well, Ms. Abramson continues, that's a matter for argument or for the people to come up with some alternative proof as to whether or not the citation can still be found. The court says, has anybody tried to obtain the actual court files or citations? Or Ms. Nahara says, no. The court says, I'm sorry. Ms. Abramson says, we haven't, but we certainly could try. Mr. Levin says, Your Honor, the people have not objected on the grounds. They've only objected on the authenticity of the document. The court says, all right, well, my concern is just the interpretation of it really is the issue here as to what is the jury supposed to do with it. There are a lot of numbers and dates and things, and it would require someone to interpret it for them, really. Huh? That's really the how you're going to be using in some way is to ask the jury to interpret it. Mr. Levin says, well, I think that's the purpose. I asked the court to take judicial notice of the vehicle code section of 12951A is to establish that that provision in the California Vehicle Code is one that relates to no driver's license in one's possession. It tends to prove by inference that he didn't have a driver's license. That's all I'm offering it for that day. I'm not offering it for any other particular purpose. Surely it may carry that inference, but the people haven't objected on that ground, and they can't impeach, or they can impeach or refute it for, or do whatever they wish. The court says, I'm not talking about inferences really at this point. I'm talking about interpreting it. There are disposition codes in court which I have no understanding of whatsoever. Do you? Ms. Abramson says no. Mr. Levin says, I never have. I never could read those. The court says, somebody does. Part of the defect in a document like this going to a jury is that it needs to be interpreted by somebody. Ms. Abramson says, all that we need is for the jury to know that he was cited for not having a license in his possession. I don't think the disposition, unless the people can prove that there's a disposition that's contrary to the inference that they're raising, I don't think it matters if the jury understands the disposition. So the defense wants to offer this just to prove, like, hey, he got pulled over at this particular time. It corroborates the fact that he said he didn't have his license. And the court is like, well, I don't get what that proves. Well, it helps prove Erik's telling the truth about something. That's what it proves. It's evidence. That's why she should be able to bring it in. But for whatever reason, this judge just doesn't like to give the defense much. Unless the people can prove the disposition. Oh, I read all that part. Okay, sorry. The court says, well, has this been marked as an exhibit yet? Yes, says Ms. Abramson. The court says it has. In this trial, it's 366, Your Honor, says Ms. Towery. The court says, all right. So right now, there's nothing further to argue. He's indicated the date he was stopped for the ticket. He's already said that. So at this point, what we really are arguing is whether or not this document should be received. Ms. Abramson says, or whether the court can take judicial notice based on that document of what that code is, that he did receive a citation. The court says I could. Maybe the people then would ask me to take judicial notice of how those tickets are cleared by producing a license. What does it prove? Ms. Abramson says, I'm sorry, Judge, I can't deal with this right now. When we come back, the court says don't deal with it right now. Ms. Abramson says, I don't understand the court's nitpicking on whether every piece of evidence we offer proves an ultimate fact while the people are allowed to put in pictures of wrong watches. It seems there's a double standard going on here, in all honesty. She's not wrong. This proves what we want it to prove. corroborates my client saying he got a ticket that day for a certain thing. He says the reason is one thing. If the people can prove otherwise, let them. But for us to assume that they can prove otherwise and therefore keep a document out, I don't get it. The court says, okay, Mr. Levin, did you want to smooth the waters this time? What a jerk. I can't stand this judge. Ms. Abramson says, yeah, let him smooth the water. Mr. Levin says, am I the good guy or bad guy? Ms. Abramson says, we switched roles to keep the court off guard. Mr. Levin says, Your Honor, the state of the matter is, I know the court knows this, but Erik Menendez used a driver's license belonging to Donovan Goudreau to purchase the 2 shotguns. The inference that the people want the jury to receive from the evidence is that this was a conscious attempt to conceal and somehow keep secret the fact that the shotguns were purchased for obvious and various purposes to go directly to the issue of premeditation and deliberation when there is no sinister reason for him to have used the driver's license that he used because of the fact that he didn't have his own, and the state of his state of mind was he had to have a driver's license to even purchase shotguns. This evidence, if received, would allow the jury. This document is a public record which shows that 1. Erik Menendez didn't have a driver's license in his possession very close in time to the events in question, that he has a penchant for driving without his license, of course, our view is that from the testimony of Erik Menendez that he didn't have a driver's license at all was the reason why he used the license of Donovan Goudreau. But this particular document we feel, is very critical in establishing otherwise inference innocent inferences and taking the court's jury instructions that it's going to give regarding the use of circumstantial evidence if one piece of evidence goes to an innocent purpose, and the other interpretation can be one of guilt. They must adopt the one that goes to innocence. This is a critical piece of evidence for the jury to follow that jury instruction and be able to give meaning to an argument that Erik Menendez utilized Donovan Goudreau's license because he didn't have in his possession his own because he didn't have one. The court says, okay. Mr. Levin says, and it's not remote because it's very close in time to the event. The court says, no one's talking about it being remote. We're talking about the interpretation of the document. And again, we're talking about the receipt of this particular exhibit, number 1 and number 2, proposal of the court taking judicial notice of the particular state of the law. The people had objected to the court taking judicial notice until they had a chance to consider it. We're now discussing it. I haven't heard the people's position as to what it is that they view as far as how the court should take judicial notice of the issues that were being discussed or that we've been discussing. I'll hear the people's position on that. Mr. Khan says, well, the missing link in counsel's argument is once again getting that document before the jury. Counsel has already established through the witness that he received a ticket at some point. Counsel now wants the court to take judicial notice of what a particular vehicle code section means. The missing link between the two is the document which establishes that their witness received a ticket for a particular vehicle code section. So again, counsel has to find some way of getting that document in before the court, and I don't think that he has established an adequate basis to get the document before the court. I think it's necessary to lay a foundation through a witness who understands the meaning and the nature of the document and can explain the nature of the document to the jury. So we would object to judicial notice at this point because the document is not before the jury. The court says, okay, he's not asking for judicial notice of the document, he's asking for judicial notice of what it means by section 12951A. Mr. Khan says yes. And we would object to that because there is no admissible evidence before this jury that that particular vehicle code section has any meaning to this particular case. He can't ask this witness, did you receive a violation for 12951 by showing the witness the document unless the witness can specifically recall the vehicle code section for which he was cited. That issue doesn't even arise. It's my understanding that the witness has not established that. The witness has only said that he received a ticket for that. Court says, all right, my concern is not with the meaning of section 12951A. It's with the interpretation of this document. The defense submitted to me, and I don't know if it was submitted to the prosecution, copies of research done by one of the deputy public defenders on this subject, but my feelings is that although the court can take judicial notice of this type of document for certain purposes, for it to go to the jury in the face of an objection, there has to be somebody from the Department of Motor Vehicles to explain what the document is. Otherwise, it would have no meaning and it would create a potential for confusion. Mr. Levin says, Your Honor, that's not my. The court says there are people available, I assume, who could explain the document. Mr. Levin says, Your Honor, my understanding of the law is because of the multitude of 40508 cases, failure to appear, certain minor infractions, driving violations that would literally stop the entire system of justice when it comes to putting on evidence of when a person received notice of a certain violation, that very specific laws have been established with regard to public records and DMV records. Otherwise, every time a motorcycle officer that cited somebody concerning no license in his possession and now has to be proven to some magistrate. The court says, okay, we're talking about an infraction. Mr. Levin says it would require the entire system to shut down. You shouldn't have to know the actual name or code in order to bring this in either, is stupid, but whatever. Court says we're talking about an infraction versus a document going to a jury without any guidance to the jury as to how to interpret it. All I'm saying is, Mr. Levin says, I'll call Detective Zoller. The court says, I don't think there's a big problem in getting somebody from the Department of Motor Vehicles to explain the document. Ms. Towery says, did the court indicate that an alternative to giving the document to the jury would be that the court could take judicial notice of that document as a public record and instruct the jury as to what that relevant portion means? The court says, no, I don't know. Did I misunderstand? The court says, I didn't say that. I said, we're not talking about taking judicial notice of 12951. That is not a problem. The problem is interpreting the document. Why do you need to interpret the document if all they're bringing in is to prove the fact that he got it? Mr. Levin says, Your Honor, I am not as interested in the document itself coming in as I am for the jury to be informed that on that date, Erik Menendez received a traffic citation having no license in his possession. And certainly the court can look at the document and take judicial notice that the official record before the court indicates that Erik Galen Menendez received a citation on July the 7th, 1989 for 12951A for driving without a license in his possession. Ms. Abramson says, we could call Detective Zoller to do the same thing, Your Honor. I assume he knows what the vehicle code sections are. This is a document that he ran. The court says he wouldn't be able to testify about it. Okay, so now you're just being difficult. What is the people's response to the court taking judicial notice of this document as an official record that shows the arrest, or the citation rather, of each of these dates? Mr. Khan says, may we have a moment? The district attorneys confer with each other. Mr. Khan says, again, we would object for the reasons stated, and is that although the court can simply take notice of the fact that that is an official record, the more significant is the meaning and interpretation of the document, and without that, the court says, why can't the court take judicial notice of that? Mr. Khan says, well, I don't think that the court can just take judicial notice of the fact that there's a particular citation as referenced on that document without knowing the disposition of that particular citation. Why? Why is that? Says the court. Mr. Khan says, well, because I think, well, all right, if the court takes judicial notice of that, then we'll ask the court that sometime in the people's case to take judicial notice of other facts relating to that vehicle code section during the course of our case. The court says, well, I can't rule upon that in the abstract. All I'm talking about now is why can't the court take judicial notice that, as this point, the defense is asking for one date, that the records of the Department of Motor Vehicle indicate that he was cited on a particular date for driving without a license. All right, says Mr. Khan. Mr. Harris says, Your Honor, may I just add something having to do with this? The court can take judicial notice of that. The problem is the only reason that that particular fact is relevant to the case is because counsel wants to use it to show that he is not in possession of a valid California driver's license. The problem with putting that document in or discussing that document or taking judicial notice of that document without having someone come in to interpret that document is, my understanding is that document shows the exact opposite. That document shows that he does have a valid California driver's license. I believe it says it's not suspended or revoked. Ms. Abramson says lost. I don't know what that means. She's probably lost with Ms. Nahara's argument. Ms. Nahara says, I understand that, or that he lost it. Yeah, she's saying he lost it, not that it was suspended or revoked. She's saying he lost it. I understand that, but what counsel, that particular document doesn't show that it's suspended or revoked. They're saying that it shows he lost it. That document does not prove he lost it. All that document proves is on a particular day, July 7th, 1989, he didn't have possession of the document. From there, that's exactly what they're trying to prove, though, with it. So that's why they wanted in. So that's all they needed for. All they wanted for. But you guys are making it difficult. From there, they want to help make they want to make the leap that he had lost it, that it's evidence that he lost his driver's license. And what we're saying is it really isn't relevant to that because it isn't evidence that he lost his driver's license. It's only evidence that on that date he wasn't in possession of it. The court says, okay, that goes beyond what the court, Ms. Nahara says, and I guess what we're saying is, what if the court is going to take judicial notice of what that code section is? Then to take judicial notice of that, the court would have to take judicial notice that the defendant did, in fact, possess a valid California driver's license, and that the code section 12951 merely shows that on July 7th, he was cited for not being in possession of a valid California driver's license. Ms. Abramson says, that's all he testified to. The court says, I can't say that he possessed it. All I can say is from these records that it hadn't been revoked or suspended. He was entitled to drive a motor vehicle. Ms. Nahara says, I didn't say he wasn't in possession. I said that the court can only take judicial notice that he was not in possession of a valid California driver's license, which he did, he was entitled to, and those records show that he did have a valid California license. The court says, now that the issues have been narrowed to some extent, why don't you put it in writing exactly what it is you want the court to take notice of, Mr. Levin, and show it to the prosecution? All right, let's have the jury out. We didn't have a break, says Ms. Abramson, and the court says, too bad. Ms. Abramson says, it is too bad, I have to go to the bathroom. The court says, make it very quick. He is a jerk. I'm sorry, but he just is. And I don't know. It's wild to me how much they just want to fight everything. They're just not letting the defense do anything. Like, I just can't even bring this piece of evidence in to prove that my client is saying something that he's saying. I can't even bring that in. It's ridiculous that they're arguing this. Just ridiculous. Hold on. All right, I think that is where we're going to end it for today, and we will pick right back up where the court gave Ms. Abramson a very, very quick bathroom break, and then the jury is going to come right back in, and direct examination is going to continue. So we will see you guys next week for that. Thank you so much for watching, and take care, guys. Thanks again for watching. Take care. Have a good one. That's the end of this Trial Transcripts Exposed. Thanks for following along with me. Like if you want more, subscribe, and let me know what you think in the comments below. See you next time.